best judgment at the time. As I said, I think if we had involved a larger group of participants, the risk of leakage of information that would give rise to further dissipation was increased. And so we wanted to avoid that, and that's why we didn't enlarge the group of people who were privy to the information about the freezing order.
So I would like to understand that a bit better. Of course, you have mentioned that these were not ordinary times. They were extraordinary times, and there was a lot of chaos. However, the order makes mention of about 5 stakeholders. Now, in my estimation, 5 wouldn't be a large number to confide in. So with that, because you do mention that the fear was the dissipation of the assets, and I note that it took the government 4 months to have a grip on the assets, to secure the assets. And of course, you have mentioned that this particular commission was not high up on the list of priorities. However, I'm trying to reconcile that with the fear of dissipation and not involving the other stakeholders, especially in the implementation, because on the one hand, it is said that the assets were being dissipated, and on the other hand, the institutions that could have easily seized control of that and contained that dissipation were not put in the picture. I'm really struggling to reconcile the two. Perhaps if you could offer some explanation or guidance on that.
Let me make one clarification first. I didn't say that the commission was not high on the priority list. I said the assets were not high on the priority list, because the Jammeh Commission was not only dealing with the assets, there were other institutional issues as well. And the whole idea was for them to identify those institutional shortcomings in the course of the 2-decade rule of the former president, so that the government can put in place mechanisms to prevent recurrence. So the Jammeh Commission was not only about the assets. The assets was only a part of their mandate. But it was the assets that I said were not very high on my priority list at that time, because we were dealing with more structural governance issues. That's the first clarification I wanted to make. The second is this. You just before the break, you described our communications as irregular, because it would involve phone calls, etc. And I guess the bottom line is because they were not written communications. And if we were to use your regular communications, that means we would have had to write to these institutions. First, the time it will take for these communications to get to them, and secondly, time was of the essence. We needed to act, and we needed to act immediately and decisively. And so those regular communications really weren't the best option at that time. But secondly, yes, we could have involved wildlife and livestock in the discussions before the application. But don't forget that we are not dealing with individuals here, we're dealing with departments. And the risk of information leaking out in those departments was real. And it's like I said, it's like the police doing a dawn raid, and you inform the neighbors that you are coming to do dawn raid. Then obviously the risk of the suspects getting away increases. And so it did not make a material difference to us in the end whether they were informed before the order or after the order. So long as they were informed and they needed to look for ways to implement this order, that was okay for us. Perhaps for them, if they had had prior notice, they would have put in place the mechanisms to make sure that they take over a sector. That's very possible. But then it becomes a question of balance. Which one do you? So these decisions are not very straightforward. You had to consider the pros and cons of every option, and you make a decision based on your best judgment at that time. And that's what we did. We went for the order. We managed to secure the order, and then inform the parties who were supposed to take over.
Okay. And of course, it is your belief that they were informed, but the fact remains that they were not. They were not informed. And one could also argue that that same fear still lied against Augustus Prom. And one could further argue on that same point that at least these other two institutions were government institutions. Now, if government cannot trust itself, it ought not to trust the third party. Just the proposition. What would you say to that?
In principle, you are correct. If these were normal times, a normal situation, you would be absolutely correct. But the new government was coming in at a time when the old government had spent over 2 decades planting its roots across the entire length and breadth of the government. Trust in government institutions was not at a premium, let me put it that way. Simply because you don't know who you're dealing with. You don't know where their loyalties laid. You don't know who was still sympathetic to the old order. There are all of these issues that you don't see from the outside, but from within you see, because you live through it every day. And so yes, we could have informed these two departments. We did not, for the reasons that I have given you. And like I said, if you were to put me in that same situation again now, I would do exactly what we did at that time, because at the end of the day, it's about balancing the different interests. It would have been ideal, perfect, because there's nothing wrong with us informing them beforehand. Ordinarily, it should have been fine. But we were dealing with a situation, we were dealing with a circumstance, a set of events, an environment that we weren't even sure about. We're talking about 3 months into the new government. So a lot of things were not very clear to many of us who were coming into the government newly. And because of that, there was a lot of circumspection in our dealings with government offices and personnel, simply because we didn't know who we were dealing with. So it was a very difficult process. You had to work with people. At the same time, you don't want to give the impression that you don't trust them, but the reality is you don't know who to trust at that point in time.
Fair enough. So after the order, there was this meeting that we will now refer to as the first meeting of the implementing task force, the implementation task force. So the task force met. What were they meant to achieve in that meeting? From a policy perspective, what were the instructions?
Well, it was to implement the order of the court to make sure that they take custody and control of the different assets that were entrusted to them by the court order. That would have been the primary objective of that meeting.
Now, was there a mechanism put in place? Again, I come back to mechanisms, but a mechanism put in place to track that fact of them having custody of these assets?
When you say mechanism, you mean whether there were efforts to inventorize these assets by these respective.
Well, not quite. The committee is well aware of the inventory efforts, and we will delve into that immediately after this question. What the question is referring to is if the MOJ had put checks in place to verify that indeed these different institutions had in fact taken custody, and that exercise was ongoing.
And what sort of mechanisms would you envisage that the MOJ could have taken to make sure that there was verification in view of?
Perhaps a monthly checkup on each institution, a monthly report from each institution, a verification, a letter verifying from each institution that indeed we have done such and such and such. Because the question has been asked on the backdrop that this order of the 22nd day of May 2017 was time-bound.
Yes.
It was time-bound for a number of days, about 180 days.
6 months.
Right. Now, within those 6 months, whatever activity the applicant had partaken in needed to be reported back to the court. Now, of course, to report back to the court, you have to have the facts. So you would have needed to put in place a mechanism to get those facts in order to report to the court. And that's what I mean by a mechanism.
There are two parts to your question. One is reporting to the court, and the other one is a mechanism for follow-up.
So the question essentially is for the mechanism for follow-ups. However, it's been asked in light of the fact that you would have ought to report it back to the court.
No, not necessarily. There was no obligation to report to the court. Well, yes, the extension would have been a fresh application for extension.
Yes.
But not necessarily to report on the exercise. What you would do typically in an application for extension is to say that you haven't concluded on your investigations, therefore you need an extension.
Yes, but you would agree that that in fact is a report to the court, that you have not concluded because of X and Y and Z.
You could qualify it as a report or as an update on the progress of your investigation.
Then let me dial down the word report to updates.
Okay.
Whatever. They can be used interchangeably in this instance, but please, go ahead.
Did the ministry have the resources, the capacity to monitor these institutions who were assigned the task? Was the ministry under a legal obligation to do so? I think that's the first question, as a matter of fact. The court order was directed at these institutions, not at the ministry, even though the ministry was the applicant. So if the court order was directed at these institutions by the court directly and not through the ministry, what would have been the legal basis for the ministry to continue to monitor the implementation of the court order? That's the question that I am.
All right, so I suddenly find myself on the witness seat. Right? All right.
I'm sorry, I didn't mean
fine.
to.
That's fine.
But I'm just saying.
All right, let me also perhaps speak out loud and say the two parties are the state and the former president. And the state is being represented by the Attorney General, as you had inferred to.
Yes.
The Attorney General represents the state. Yes. Now, every single institution, except for Augustus Prom, that was bestowed upon assets, is a state institution. Sorry. Now, in case they default and they are to go to court, who is to represent them?
Yes, the Attorney General represents
It would be the Attorney
the
General.
government, but
So-
they have their line ministries.
I understand that. However, from my standpoint, it is the government of the Gambia as a bloc
That's right.
that sought for the order, and the court bestowed the order upon the government of the Gambia in its respective institutions, but the responsibility is as a bloc.
Yes.
And so I would actually indeed say that, yes, the Ministry of Justice was legally bound to follow up the order that it sought and report back to the court.
I think we would have a difference of opinion here because,
Very well.
as you rightly say, the government has different components. Ministries form part of the government. For instance, livestock marketing agency is under the Ministry of Agriculture. They were ordered by the court to take over the livestock. Wildlife is under environment, I believe. Ministry of Environment, they were ordered by the court to take over wildlife. And so they have their line ministries to report to. They owe no obligation, or they owe no reporting obligation to the Ministry of Justice. The Ministry of Justice is the principal legal office of the state, and if the state wants to go to court, it uses the ministry, and that's what we have done. But in terms of supervising and monitoring what other government departments do, I don't think that's constitutionally or statutorily the responsibility of the Ministry of Justice.
When you put it like that, I'm inclined to agree with you. However, allow me to put it a different way. It is the government through the ministry who applied for these assets to be preserved. Now, from all indications, it is the ministry who suggested that such and such an institution should be bestowed upon assets. I would stand my ground and say that indeed it is for the ministry to receive those updates from the respective institutions highlighted in the order in order to update the court.
Well, I suppose you're entitled to your opinion, just like we are all entitled to our views. I am saying that if the other departments form part of the government and they have their line ministries, the ministry, in terms of the application before the court, has no option. If the government is going to court, it has to be the ministry that goes to court. That does not mean the ministry takes responsibility for the actions of the other ministries.
The government does.
As the government does. And these other ministries form part of the government.
Of course.
And these departments are part of these ministries that form part of the government.
Indeed.
So the departments report to their line ministries. They don't report to the Ministry of Justice.
Yes, but you see, Mr. Tambedou, when there is liability to accrue, who suffers? It is not Gilmer. They will not feel a pinch of it. It is not wildlife. They will not feel a pinch of it. It is not Ministry of Justice. You, or the ministry rather, will not feel a pinch of it. It is the government of the Gambia that will feel the pinch. Because
as a whole.
As a bloc, yes. Yeah. The government would be the one to disperse those funds from any liability.
Yeah.
And that's precisely my point, that governance is a collective endeavor.
Yeah.
And we can't separate the blocks. Yes, the Ministry of Justice is statutorily obligated to be the one to conduct the matters, but it's conducting the matters on behalf of the government. Likewise, Gilmer is to have custody of assets on behalf of the government. So you would see the trend that all these institutions are acting on behalf of the government.
But now you want the ministry to supervise the activities of the departments under other ministries.
The word is not supervise, it's to receive updates or to request updates, to monitor perhaps the word monitor was interpreted by you as supervision. Not necessarily. But in order for the Ministry of Justice to go back for an extension, it needs to file an affidavit, an application and an affidavit. And the affidavit is just facts. And those facts are not within the Ministry of Justice. Those facts would be at Gilmer, those facts would be at Wildlife, and all the other places, perhaps the Registrar General, to relay that to the Ministry of Justice, and for the Ministry of Justice to transmit it to the court.
No, for purposes of applications for extension, because the application is premised on investigation by the competent authority, in this case the Attorney General. And for purposes of extension, perhaps you should look at the applications for extension. I haven't seen them since those days. But the applications would have been premised on the ongoing investigations by the competent authority. So, in other words, there was no need for information from any of these government departments on the assets that they were entrusted with. We didn't need to go to Gilmer or Wildlife to get the facts to go to court for extension. All we needed to do is ask the court for an extension on the basis that we have not concluded our investigations. But to now ask these departments to report to the ministry on their activities over these assets is to really put a burden on the ministry that is neither constitutional nor statutory.
You see, Mr. Tambedou, I think this is our first point of conflict. It has come. And I would stand my ground to say,
okay,
I would disagree with you. If I could relax the scenario a bit, and I could see that from 2000 to 2003, you were in private practice. And you would know that as a lawyer, it is for your client to give you the facts. You cannot manufacture the facts. And even if where you're going to sort for an extension, there's still need for facts to be adduced as to why you need the extension. And the court would not just grant it out of grace. It would listen to those facts and weigh them across the spectrum and grant or deny. Now, the court would grant where the facts lead to granting the application. And those facts, again, are not with the MOJ. Now, the MOJ would need to, let me use the traditional lawyer-client relationship to say that the MOJ is the lawyers, is the law chambers for the government. Now, your clients would be presumably the institutions in the government. They have been asked to conduct certain seizures and to control certain assets. Now, whether that fact of control has occurred or not is a material fact in order for the court to extend its time on the interim injunction. Now, of course, the court would also ask you, or the Ministry of Justice, as soon as the application is made, whether its previous order was heeded too, because we all know, or you and I know, how courts dearly hold their authority and orders. That question would have been asked in court, and it would have been answered by the MOJ that yes, in the affirmative or in the negative. Don't you agree with me?
You see, would have been is very speculative. And your assumption is right. In the ordinary course of things, questions will be asked. But it's only an assumption. But let's find a point of entente, as we say, a point of convergence. If you say that the applications for an extension of the freezing order would have been accompanied or would have been underpinned by facts provided to the ministry from the other departments, I will say that if that is indeed the case, and we have had multiple extensions based on applications, then it means we would have received some facts from these government departments and presented to the court for our applications for extension to succeed. So I am meeting you halfway, counsel, if you like, and say if you are of the belief that there had to be factual basis other than the ongoing investigations by the competent authority, I'll give you those factual basis because we have applied for extensions and we have received those extensions on a number of occasions, I believe 2 or 3 times. So if those extensions were underpinned by the facts we got from these different departments, well, then it means we have satisfied your theory about what the MOJ should have done.
All right. I was trying as much to follow your response. I can see you agreed with a lot of what I said, but also distance yourself from a lot that I said.
No, I'm just being pragmatic here.
Yes.
If the underlying assumption of your approach is that for us to go to court to seek an extension, we needed to have gotten facts from the departments, and since it was the case that we went and got multiple extensions based on applications, so I am saying by deduction we would have gone or we would have received the facts that would have allowed us to seek the extensions. So I'm meeting you halfway.
Okay. All right, because this question began when we were discussing the issue of a mechanism of monitoring, whether such, whether the dictates of the order were actually heeded to or not. And in that spirit, the process in court was basically context. So is the answer to that question that there was no such mechanism?
The Ministry of Justice didn't have the constitutional or statutory mandate or indeed the resources to engage in any acts of monitoring departments that were under borderline ministries at that time.
So I would take the answer as it pertains resources, but not constitutional or legal, because I am not taking you into a constitutional or legal debate. Or
yes, but the ministry carries its work out in accordance with the constitution and statute.
Of course, and
yes.
So does the court.
Yes, and those are very clear in terms of the limitations of the mandate of the ministry.
Yes, but this is not, we are not speaking of the mandate of the ministry. We are speaking of the responsibility of the ministry as it pertains this order here.
I agree with you that the ministry has responsibility,
but
that responsibility does not extend to monitoring or supervising departments that are under other ministries.
But it would extend to receiving the necessary information from those institutions.
Why not? Of course, if the information is given to the ministry, we would gladly.
And if it's not given?
It. Well, that's where the monitoring and supervising comes in. Is there a duty to monitor to the extent of reaching out and seeking information in terms of how the court order is being implemented? Is that a duty you think the ministry should have had? And if so, based on what?
So, not the way you put it, but the duty is that because the ministry was the applicant, on behalf of the government, of course, the ministry was duty bound to ensure that the order was implemented as the court envisioned. Do you agree with me?
But you see, that's perhaps maybe where we are not reading from the same hymn book. The ministry is a vehicle through which the government made the application.
Yes.
So it was the government's application, not the ministry's application.
I agree.
Yes. So if the government made the application through the ministry and the government obtained the order
through the ministry,
yes. And that order is for government departments to take custody of the different assets.
Yes.
then the ministry is in the same position as the other government departments, because the ministry also has the Registrar General under it,
Yes.
who was given assignments
Yes.
under the order. The ministry had Augustus Prom, whom it identified and appointed as receiver.
Yes.
And so the ministry was dealing with its part. There are other government departments, ministries, that were also supposed to deal with their part.
True.
If you see what I mean. So the ministry was just a vehicle to secure the application by the government. And the ministry is part of the government together with the other ministries. So the ministry cannot be supervising what other components of the government were supposed to do.
All right. So I agree with everything you said, except your last statement. Your last statement is that the ministry should not supervise the work of other departments.
Of other departments in other ministries.
Yes. And if the statement is put in that way, I would have to agree with you. Because it is not the Ministry of Justice's mandate to look into the administration or anything of Gilmer or any other institution that is not in its line of work. But the ministry had a responsibility to the government and to the court to ensure that the order was heeded to. And I like the fact that you had painted the ministry to be a vehicle. And that vehicle should have kept running to Gilmer to ensure that the vehicle, because to ensure that MOJ facilitates notice of the order to Gilmer and to wildlife. Because it is true that, yes, the Ministry of Justice was a vehicle for the government to obtain the order. My proposition to you is that it is not, the facilitation did not end at obtaining the order. The end of the facilitation should have been implementation of that order. And precisely why you had instructed your subordinates to form up a team to ensure that implementation was done. Now, the ministry would have not done that if it wasn't, if I can say, the agent of the government responsible for the Jammeh Commission or issues surrounding the assets of the former president. And to underscore that point, you see, you've mentioned that the Registrar General was in the loop. I agree with you. That is because he was in the loop even before you went for the order. You mentioned that Augustus Prom did his part. I agree with you because he was in the loop way before you got the order. But you see, the two institutions I refer to were not in the loop before you got the order, and from what this committee has received, they were not in the loop after you got the order. So that's what I am trying to reconcile. And that is where the duty of MOJ and yourself at the time should have kicked in. Facilitation. Now I will do away with monitoring and supervision. I think we can agree to do away with those two words and say that you should have facilitated receipt of the orders.
I hear you. And as you were posing your question, I was thinking, then what would have been the responsibility and the obligation of the line ministries of those departments? Because if the Ministry of Justice was to facilitate, you have agreed to perhaps not use, monitor or supervise, but if the ministry was to facilitate, what would have been the role of the line ministries of these government departments? Because it's a shared responsibility in government. The Ministry of Justice had its part, and these other departments had their part, but they fall under different ministries and not under the Ministry of Justice. As far as the Ministry of Justice is concerned, we had the Registrar General, and I would be happy to take full responsibility for any thing that the Registrar General failed to do in the course of executing the mandate given by the court, and indeed for Augustus Pom as well. But for the other ministry or for the other departments who fall under other ministries, it would be a stretch for me to say that the ministry had any form of role, facilitative or otherwise.
So just to get your perspective, you were saying that the ministry had no duty to put Gilmer or wildlife, the department responsible for wildlife, on notice.
Oh no, not about notice. I did make clear that as far as I know, notices would have been sent through the ministry. So it would be an interministerial correspondence from the Ministry of Justice to the Ministry of Environment and Agriculture, respectively. Now, whether communication cascaded down to the departments, I do not know. But I would want to believe that we would have written to these ministries. If we did not, then it was a gross oversight, if we did not.
All right. From what the committee has received, the MOJ did not. So you do confirm that that was a gross oversight?
If indeed we did not, certainly.
No evidence has been brought forward to the committee that notice was given. I'm sure you haven't finished your hearings yet. There may be other witnesses on the way who may be able to provide additional light, or maybe the Ministry of Justice could. I think they should look into their files. I would be very shocked to know that no official communication was sent. But in any event, if it wasn't, it would have been an oversight, certainly. And also, on the issue of Gilmer, now, Gilmer, that is Gambia Livestock Marketing Agency, was established by an act of parliament. I believe they have their own board. Now, I don't dispute the fact that their line ministry is the Ministry of Agriculture, but for all intents and purposes, they are independent. Perhaps where the ministry would come in as is convenient in governance is for budgetary purposes. With that in mind, isn't that an institution that could have benefited from direct notice from your ministry?
True, they could have benefited from that notice, even if they were not an independent body. I think it would have done no harm to write to the ministry and CC the departments so that they are in copy as to the order. But as far as I recall, a meeting would have been held at the ministry where all of these departments would have been represented. And because that's the information that I would have had, there wouldn't have been need for me to find out whether they were written to or not, if you know what I mean. Because the assumption at that point is that that meeting would have been held.
I appreciate that. And for the first meeting, the policy meeting that you were in attendance, I can understand why perhaps no records or minutes were formulated. But for the second meeting, I don't believe I would excuse a meeting of that magnitude not having its own minutes or a report.
Well, you know,
yet this committee is in receipt of no such report or minutes. In fact, since I'm glad that you mentioned that you would take responsibility for everything or anything that the Registrar General at the time,
in execution of the mandate as given by the order.
I see.
Oh yeah, absolutely.
So the registrar, who wasn't sure whether he chaired that meeting or not, had confirmed that there were no such minutes. Were you reported?
I was not privy to information about minutes. I was not at that meeting. I wouldn't have been at that meeting. It was an operational meeting, and I cannot say anything about that meeting.
All right. Where I'm getting at is, you see, this is an endeavor that began in cabinet.
Yeah.
That's the house of policy. Now, policy consideration was laid in cabinet, debated, I can assume, and relayed on to yourself, to your ministry. Now, it's that policy consideration that you were acting on. That policy consideration would have morphed into instructions to your team. Am I on track?
Absolutely.
Those instructions for your team to implement, unless, please correct me if I'm wrong, but those instructions warranted reporting back to the policy makers, to you and to cabinet. Wouldn't that be the case?
No. You see, when it comes to implementing policy, so operationalizing policy, that is a matter for the civil servants. The minister deals with policy and issues instructions and gets updates based on the progress of implementation.
Can I just pin you there? Updates. Can you
Yes.
elaborate on the nature of updates?
Well, if there is a significant development, typically the Solicitor General would brief me, typically. Occasionally, other staff members who are dealing with these matters would brief me as well.
In what manner?
Verbally.
Verbally?
Verbal briefing, yes. Verbal briefing. You know, Counsel, I don't want to keep repeating myself, but you're looking at things
In an ideal situation.
with today's lenses.
Yes.
We're talking about 3 months into the new government, and I don't want to repeat and bore the committee on these comments, but lawyers didn't even have computers to write on. So to assume that we had the luxury of typing out, writing, that wasn't our reality. Our reality was different at that time, and we were making the most of the situation. And so there were verbal briefings to me, occasionally by staff members who were working on these matters, but more routinely by the Solicitor General, who would inform me of significant developments. And if I can just add that at that time, if I recall correctly, and I'm not exaggerating here, if anything else, I am providing you with conservative numbers. At that time, I had no less than 5 meetings with people coming from all over, in and outside the country, a day. Every day, there were visitors flooding this country from abroad, because I guess we were on the news during the impasse. The international community was interested in what was happening in the Gambia, and they were all amused by this little country with our unique voting system, with the lack of quorum in the Supreme Court. We were on the news every day in those days. And so as a result, there were a lot of visitors in that country at that time. And a lot of things could have been done at the operational level without an opportunity to brief me. But certainly I know that whenever there was significant development, the Solicitor General and occasionally the staff members who were working on it would find an opportune moment to bring it to my attention.
Yes, I'm still trying to grapple with the idea that a whole ministry did not allocate laptops to his lawyers. I'm still grappling with that. So if you forgive me if I have to stick to that point a bit longer.
You know,
Knowing lawyers, I cannot imagine a lawyer without, a modern day lawyer without a laptop.
I think it would be helpful for me to paint the picture of the ministry at the time when I went in as Attorney General. You were talking about laptops and desktops. That was a luxury. We didn't have stationery. You know, writing pads and pens were always in short supply. We would be having meetings and our cash power would run out. And the accountant wouldn't have petty cash. Some of us would dip into our pockets and buy cash power while the accountant would run to the Accountant General's department to find money to come back and buy cash power. Our toilets were not being cleaned for days because the cleaners didn't have detergent to clean those toilets. Staff at the ministry, including myself, had to contribute every month from our salaries to buy detergents, to buy gloves, to buy cleaning equipment, and motivate those cleaners who were there. Are you seeing the picture I am painting?
It's quite grim.
Let alone laptops. There were no printers. As I said, you had pools of typists. And when I was at the ministry between 1997 to 2000, the same way that we operated in those days was what I still found at the ministry 20 years later. And so those were some of the challenges we had at the ministry. There was no internet. Lawyers weren't able to surf and do research from the internet because it just wasn't there. So that's the Attorney General's chambers at the time that I went in. And not only did was I told about this, I would walk around the ministry, both in the front building and the back, to look at the state of the offices myself and to interact with staff to see the conditions that they were working in. At the back offices, the mosquito nets were all torn, that their offices would be infested with mosquitoes. And there was no money to buy spray. They would dip into their own pockets to buy spray so that they can stay in their offices and work. Otherwise, they would just be walking around in the ministry. These are some of the challenges we found at the ministry. So to say that you were surprised that there were no laptops for lawyers, yes, there were no desktops. There was no desktop, there were no computers. Ultimately, all of that changed. And like I said, by the time I left, every lawyer in that ministry had a desktop and computer, an internet in that office.
I hope the toilets had detergent as well.
Well, we did what we could at that time. But just so you understand the challenges that we had at the ministry.
No, Mr. Tambedou, what you have painted is very grim. I do not wish to be a lawyer at the Ministry of Justice at the time, from what you have painted. However, at least you had typists. Those typists ordinarily could have been involved in meetings.
No.
To type out records of or the minutes of the meeting.
No, those typists were overwhelmed. Don't forget that in addition to all of these new additional work about our transitional justice, the ministry was still carrying out its routine day-to-day work. Lawyers were typing out their legal opinions, etc., and the typists would be typing out those opinions. The files would be piled up to a certain level because the typist had to go through each file to make sure that they type out the legal opinion and advice and correspondences of the lawyer. So we wouldn't even dare think at the time to remove those typists from that responsibility to come and type our own minutes. That would have been, it was unthinkable.
What about a traditional or conventional rather paper and pen?
Yes, minutes should have been taken. I made sure that in my case, when it was important, minutes were being taken. But like I said, at the operational level, I don't know how things were really done to that minute detail. So I wouldn't be able to tell you anything about that.
But just to stick on that point, I would contend that you ought to have been in a position to tell us what obtained, because your team ought to have been in a position to report back to you, even if it's, as you said, verbally, but to ensure that they report back to you at every step of the way. Perhaps not on every single aspect, but on every single material issue. You should have been in the picture, because you had mentioned that Cabinet had allowed you, had made the decision was made in Cabinet to go after these assets, and Cabinet had allowed you the latitude to see how you would get it done. Correct?
Yeah.
Yes. So in that spirit, because you had someone to report to as well, wouldn't it have made sense for your team to periodically report to you?
But that's what I said. I said when there were significant developments, I would get briefings from the Solicitor General, absolutely, and on occasion from the staff members who were directly involved in the matter on significant developments. Yep.
Those briefings were never made in writing.
I don't recall. They could have, but I clearly remember verbal briefings on certain activities. I don't recall whether they were in writing. They could have been in writing, but I don't recall.
Fair enough. So what was this team supposed to do?
The team that was...
Implementation team.
You know, you're asking me on operational matters, and I don't know what to say. Yes. Except that the orders were clear. The court order identified these the offices that were entrusted with these responsibilities, and I believe the meeting, that operational or implementation meeting, should have been about what those responsibilities are. In the case of the Registrar General, it was about planning to make sure that adequate steps were taken to inform, preserve the assets, properties that were entrusted to him. Yeah.
Yes, you had just mentioned that it's the court identified institutions. Of course, it was with your suggestion, your ministry's suggestion, that the court identified the institutions.
Yeah.
Your ministry is the one that suggested it to the court, and the court adopted your suggestion.
That's right.
Yes. So the responsibility of what these institutions were to do should have emanated from your office.
But that's why we had the meeting, so that they would be informed about the court order and what they were supposed to do. We don't have the expertise. We just convey the order, yeah, that they had to take custody and control of these assets, and how best to do that would be left to them.
Yes. Again, what I'm trying to reconcile is the ministry made a decision that we would get Gilma involved, we'll get the department responsible for wildlife involved, because they probably have the prerequisite skills or know-how to take care of these assets. And once the order was obtained, that information was not relayed to these two institutions.
Well, we haven't established that yet, so long as your hearings are continuing, because I don't know what
as of today.
As of now, yes.
As of now,
you qualify.
Yes. As of now, nothing was communicated to Gilma or wildlife. So I am tempted to say that your ministry, in fact, failed to transmit notices of this order to the respective institutions concerned.
If we did not write to the respective ministries and they were not called to attend this meeting that we are referring to, then we would have failed in our responsibility to inform them. Absolutely.
All right, Mr. Tambedou, unless any contrary evidence is laid before this committee, the position this committee is taking, and the position from the records, is that no such communication was given. Also, not just from the records, but from evidence given on record by those two institutions, they did not receive any correspondence from the line ministry or the MOJ as regards to the order. Now, I feel as if I'm duty bound to tell you that Gilmer, in their submission to the committee, did mention that after a while, when they were inactive, they did get a correspondence from the Ministry of Agriculture asking them to take control.
When did they get that correspondence?
Sometime in June.
When in June?
Well, I am not in a position to say.
Can I have a look at that? Is that the communication you have?
No.
Okay.
It is not. Perhaps tomorrow you could have a look at it.
So you're saying that Gilmer has accepted that they were informed by their line ministry of this court order in June?
Yes.
The court order was granted on the 22nd of May.
Yes.
In the last week of May.
Yes.
And you think that's abnormal, unusual for correspondence to emanate from the ministry to Minister of Agriculture and from Minister of Agriculture to Gilmer in that period?
Certainly not, Mr. Tambedou. I do not think it's strange. However, from your own testimony, there was expediency at the time. There was need for urgency. There was pressure. So my assumption is that even though it is government's modus operandi to have bureaucracy cloud or clot rather correspondences from flowing effectively, these were not ordinary times. As you yourself mentioned, there was need for speed, there was pressure. So I would imagine that the Ministry of Justice would act in that spirit. Since there was pressure, they would act with need for speed.
And the Registrar General, when he came here, said he didn't call Gilmer and the others to a meeting at the ministry soon after the order?
The Registrar General, I don't believe he even gave us a proper account of that meeting.
Yeah, I'm saying, did he confirm that he did not call?
He could not remember much. He confirmed.
He could not remember that.
Yes, he confirmed that he did not call.
He confirmed that he did not call.
Yes,
and that no one called Gilmer and the others.
Indeed. Well, for Gilmer, he maintains that they were in the meeting. He maintains that they were in the meeting.
Oh, so the Registrar General did say Gilmer was in the meeting?
Yes, but after saying that, he did say that he was not sure. In fact, he was not sure who chaired the meeting. So the committee is skeptical to take his account of who was present in the meeting. I'm sure you can appreciate that. Because if I attended a meeting, the easiest thing to remember is who the chair was and who the secretary was.
Counsel, I will be very surprised if there was no phone call to Gilmer or Wildlife to attend a meeting at the ministry, because that would have been my instructions to reach out to them immediately, even if we were to follow it up with a letter. And you're absolutely right. In those days, in this particular instance, time was of the essence, and we would have reached out to them. And if we did not, then it means someone didn't do their job. That's what I would say.
I would agree with you that indeed someone did not do their job. But of course, unfortunately for us, the buck, when it concerns the assembly, stops at the minister, because it is the minister that is responsible to the assembly and by extension the people. And that's why we are putting it to you that
the minister takes political responsibility for institutional failings. That should not be confused with individual or personal responsibility.
Of course not. I would not assume or suggest that.
And it's something that we will come back to subsequently, I'm sure, but it's something that we are yet to grow into as a democracy in this country. They always confuse political responsibility from individual or personal responsibility. But like I said, I am not one to run away from responsibility. I have, I think, demonstrated that over and over and over as Attorney General. And so where there are institutional failings, I would accept those failings as the reality and hope to learn from them. And we have had a few like that while I was Attorney General. So in this case, if you tell me that there is evidence, unchallenged evidence, that the ministry did not reach out to Gilmer or Wildlife to invite them to a meeting on implementation of the order, that would have been a failing. Absolutely.
Yes, and this failure would come to haunt us, as you would see in our subsequent sessions, because essentially it meant that the assets were unmanned.
Which assets?
The assets concerning those two, the livestock,
the crocodiles and the hyenas in
yes,
in Kanilai, and the
cows,
cattle, the cows,
the sheep, the pigs.
You know, put yourself in this situation. 3 months into the change, when I have described for you the political environment in the country and all the uncertainties, etc., and the tension, and with all the list of activities that the ministry had to undertake as part of its transitional justice process, you wanted the ministry to prioritize the care of cows and goats and sheep at that time. That's what you wanted us to do.
Pardon?
I was saying, given everything that was happening in the country at the time, you wanted the ministry to focus its attention on caring for the cows and the goats and the sheep that the former president left with the resources that we had.
To take an inventory or to have them in custody?
I believe inventories were taken for these. Were they not?
What is your question in relation to?
No, I'm saying, you know, you were saying you made a comment that that failure has cost us. And I'm saying you have to contextualize that failure.
Yes.
The fact is, with everything that was happening in that country, 3 months into the change of government, and this was no ordinary change of government. It was not a smooth democratic change of government. We had a military occupation in our country. And what do you think that was the cause? What do you think was the effect, was the implication? In that context, you wanted the ministry to devote resources to focus on cows and sheep and goats of the former president.
Precisely. And I believe it is not just an ask that I am ascribing, but I believe it's what the court laid down. Of course, if you look at the court ruling, you would see that even the court ruling is speaking in such terms to say that the ministry is the ministry at the forefront, or is the institution at the forefront of these issues. And when you look at what was bestowed upon the Registrar General, I can argue that you need not go on from paragraph 2 of this order, because the paragraph 2 puts all movable and immovable property to the Registrar General. Is there any other property outside of those two properties?
That's why you need to understand the context of the application.
Please.
That paragraph was qualified, so you need to look at the application from the ministry in order to understand the order that the court gave. So we divided up the assets. So Gilmer would be entrusted with the livestock, etc. Wildlife would be entrusted with wildlife, the hyenas and the zebras, etc., the companies would be entrusted to the receiver, Augustus Prom, and any other assets outside these categories would be in the custody of the Registrar General. So that is how things were divided up.
Yes, so the residue of assets was given to...
Because some properties were owned by the companies which were under Augustus Prom's receivership, but other properties were not. They were in the direct names of individuals.
All right. I had asked the question about a reporting mechanism. Perhaps reporting might have not been what I had envisioned, but a working group, sort of, to be able to disseminate information amongst all the parties involved. Because, again, it was the government acting within itself. I believe from what I hear, there was no such mechanism. It was just right to the respective ministries and let them communicate to their line institutions.
A working group would have been a great idea, but a working group when? Before or after the order?
We're talking about after the order now.
I guess. Okay. I can still be heard, or it needs to be recorded. I can continue. Oh, okay.
Yes.
Okay.
We need to. Sorry. Yes. If I can get an indication whether the cameras are still rolling. They are. Okay. Yes, we can go ahead, Mr. Tambedou. As you can see, we are still struggling with light on and off. So it is not just the ministry in 2017. The National Assembly is also dealing with it in 2025. Please proceed.
I have seen a lot of change in this National Assembly when I walked in. Those who were here in 2017 will tell you also that things have changed here, I'm sure. It was not all like this. You're lucky. You're a lucky generation. Make the most of it.
We will. We will indeed make the most of it. Thank you.
Yes, so where were we?
The issue of the reporting mechanism or
Yes,
a coordination
yes.
mechanism.
A working group.
A working
Indeed.
group, yes.
If my understanding was correct, that was the whole point of the meeting that was called at the ministry by the Registrar General. I'm not sure if the Solicitor General was involved in that as well, but that was the whole point of having that coordination meeting, if you like, to have some sort of working group or task force to coordinate who was going to do what, how, when, and where, and what would be needed to conduct those activities.
Okay, so from the chronology of events, as in your perception, after that whole event of the working group, where did you come in next? Since you were not involved in the operations, where did you come in next? Is it in the conception of the commission, or was there something in between?
I cannot recall whether there was any significant activity, but certainly the concept of the commission came after a discussion in cabinet. Now, in terms of the activities of the ministry, the Registrar General, I believe, went around to serve notices following the freezing order. But before that, I called up a press conference. I always did that at the time when there were significant developments that I needed to inform the public about. And so a press conference was called where I announced the freezing order and the assets that were being frozen. And then the Registrar General went to work to do his part. Augustus Prom went to work to do their part. And yep, that was put to one side. then Cabinet now discussed the issue of a commission of inquiry.
All right. Just like I had delayed our discussion on the order, I would like to delay that discussion on the conception because it is important. But before we conceive the commission, it's important that we understand everything else around the environment in the country, what led to the government choosing a commission over other mechanisms and whatnot. So you do not recall any other material event occurring from the period of investigations occurring and the commission being set up?
Unless you refresh my memory, if there is any specific activity you have in mind, I cannot recall right now.
I do not have any suggestions for you, but perhaps I could say that you were reporting to Cabinet this whole time as they were doing the investigations.
So as who was doing which investigations?
The working group was supposed to implement the
order of the commission.
But there was another limb to the working group.
Yes.
Right?
Which was
inventory.
Yes.
Which was an investigation of its own.
Okay.
So that investigation, or perhaps let me call it the coordinated exercise, was it something that you had taken to Cabinet in form of reporting? Because I'm sure Cabinet was aware that you would take action. How you would take action, they left it in your discretion.
Yes. The inventory that was taken?
Yes.
No, there was no need to take that to Cabinet.
There was no need to take that to Cabinet. All right. Honorable Chair, I'm afraid that if I transition to another issue, I may leave it hanging for the day. I can see that my time as agreed with the committee has elapsed. I would allow the committee to weigh in. However, I would ask Honorable Chair that we stick to the themes of questioning and not go into matters relating to the commission proper until tomorrow. So if the questions can relate to the settlement of the government at the time, any issues of the political environment, and also issues surrounding the High Court order, the preservation order. Yes, I will pick up from the preservation order and transition into establishment of the committee tomorrow.
Okay, very well.
Yes, that's my first request. My second request is that we take a 10-minute break before members begin asking questions, because I do observe it's quite humid in here. It seems like our technical team did not sort out the air conditioning. So if we could just get a breather and come back, I'm sure the witness would benefit from it, just like we would.
Okay.
I don't mind at all, to continue.
Then I will excuse myself.
Okay, thank you.
Come again? Yep. Come again?
Oh yes, of course he will be. But he has his lieutenant there as well. Thank you very much, Council, and thank you, Mr. Ba-Tambedou. Usually after Council's interventions, the members of the committee will take turn to ask questions for clarity. So I would at this point invite Honorable Sar to have the floor.
Well, thank you very much, Chair. Mr. Ba-Tambedou, with regards to, during your intervention, you made mention of the political pressure and also the public pressure. That's what led to you taking action as quickly as possible. My question is, during this time, was your team ready to take up the challenge?
Thank you, Honorable, for your question. It depends on what you mean by ready. If it's ready in terms of the human resources capacity to file the freezing order, certainly we were ready. But if it is about the larger, broader governance issues, wouldn't taken the action that I took at that time. I would have waited a little bit more when the government would have had more time to settle down, when other more pressing matters were being addressed to start the work of a commission such as the Jammeh Commission. But in any event, as they say, if you do not start, you will not know whether you are prepared enough or not. And in the end, it turned out to be okay. We survived. We managed to put a team together. We managed to identify people, and we managed to apply for the freezing order based on the information we received from the Financial Intelligence Unit. And so, yes, we were ready in terms of our personnel.
Mr. Tambedou, the reason for my question is based on the court order that was received by you. We have seen witnesses coming here, and at most when they are asked, one, they have never seen the court order, they never go through the court order, but they were acting based on order from their superior to say, go and do A, B, C, and D without knowing what was in the court order. So this is why I'm asking whether the people are ready for it.
That's not unusual in situations like this, because those who are entrusted with the responsibility to implement court orders are the ones who understand what is being ordered. And it was not necessary for every member of the implementing team to understand what the court order said. So I don't see anything abnormal or unusual in that. So long as the order was explained clearly and the instructions were clear as to what the team members were supposed to do, that suffices.
Mr. Tambedou, can you please guide me here with regards to Section 51 of the Anti-Laundering Act? If you look at this section, it talks about restraint. And then if you go further, if you read further, it's very clear. Was this enough for you to freeze the former president's assets?
The Anti-Money Laundering Act, Section 51 in particular,
exactly,
is clear about a restraining order, because that is what the order says. So 51(1) talks about the application for a restraining order, and 51 subsection 3 talks about the order from the court, what order the court can give. So if you look at subsection 3, you will see the provision that empowers the court to issue the restraining orders.
Mr. Tambedou, you help me because you are legally minded. For me, as you know, my question is here: restrain. Who is supposed to restrain? Was it the former president was supposed to restrain for not selling? Can you help me here, because I want to be guided here?
Yes, the restraining order prevents the former president, his agents, those or associates from interfering with any of the properties that were attached to the annex in the court order. So basically, they are restrained from dealing with the properties in any way or manner whatsoever. So if I, for example, say that you're restrained from coming into this room, it means you must not come into this room. If you are restrained from taking an activity, it means you must not take that activity. And so the order from the court was a restraining order instructing the former president, his agents or associates from dealing with any of those properties that were attached to the application list.
Tambedou, do you have the FIU report with regards to this order?
The FIU report, which formed the basis of our application to the court,
exactly.
it must be, I don't have a personal copy, but it must be at the ministry. In fact, it was, I believe, if I am not mistaken, attached to the application. But in any event, it must be at the ministry.
Because if you look at the heading, Mr. Tambedou, restrain, seize, and for future of assets relating to money laundering and financing terrorism. Was that thing part of the reason why? Was there any iota of suspicion on this?
Indeed, I said the Financial Intelligence Unit provided us with a report together with a list of the bank accounts that were used by the former president, and based on their assessment and based on our assessment, our legal assessment at the ministry, they meet the criteria for anti-money laundering offenses in the Act, and that was the basis upon which we used the Anti-Money Laundering Act to seek the restraining order.
Making an application, if possible, if at all, Honorable Tambedou can help us to have that report of FIU so that we can use it to guide ourselves. Yeah.
Okay. Well, at the end of the time, at the end of the year, we'll liaise with the council. Regards to that.
Honorable, with regards to, you said you had challenges when it comes to the properties that were being used where Gambians were employed.
Yes.
What was the fate of those Gambians after the seizure?
Well, yes, the companies. As I said, the reason why we decided to go through the ever seen a copy of those receipts, but that's how it was being managed. So those people were allowed to continue to work in those companies.
So when it comes to receiver, Mr. Prong was employed during that time. Where do you base your reason of employing him? Was it through this section 51 or what?
Yes, there is a provision in section 51. If I am not mistaken, I don't have the act with me here, but there is a provision that clearly empowers the court to appoint a receiver. Yes, it's there. Let me perhaps look at that. Okay, 51 subsection 4, and this is what it says for the record. The court may, in granting an order under subsection 3, give directions as to A, the effective period of the order, B, the appointment of a trustee or receiver for the proper administration of the money or property during the effective period of the order. That's the provision that allows the court to appoint the receiver.
What were the criteria used to appoint Mr. Prong?
I think I have explained that. The idea was to find a receiver. Discussions were held at the ministry at the time between myself and my senior management. Names were suggested. Again, I keep saying 3 names. I'm struggling to remember the third person, but Augustus Pom was certainly one. Alpha Berry was 2. And anyway, there was a third person. And the reason why at this point we went for Augustus Pom was because Augustus Pom had prior experience in dealing with liquidation. So in the case of Carnegie, where I believe the government engage Augustus Prom to deal with that liquidation. Because of that prior experience with government liquidation, we decided to choose Augustus Prom as receiver.
My concern here is, Mr. Tambedou, you had 3 names. Were all those people invited to submit their interest, or were you only choose Augustus based on your experience?
No, we chose Augustus Prom and didn't open it to outsiders for specific reasons, and I can go through those reasons for you. First, this was a very sensitive process. We were going to apply to the court to freeze assets of the former president. And the same hesitation that we had from informing those outside this small group of people, it was the same hesitation we had to open this up to a wider group. This is about assets recovery. It's a sensitive process, and it required a lot of discretion. And we imagine if we had opened this up to everybody and say, send in your interest because we want to hire you to oversee the assets of the former president while the government is, I mean, it would again take away the element of surprise and put us in a position that would have meant people could have acted and dissipate these assets. So this is an action that you don't publicize, you don't advertise. It was done with utmost discretion, with confidentiality. That's why we only announced it after we secured the court order. So we couldn't have opened this up to a larger group of people to submit their interests.
I'm not saying you advertising, but when you identify 3, could have invited them to come and submit their interests, sit together and look at the best out of the list that you had. Because like along the line, Prong was terminated and Alpha came in. So I didn't mean that this thing happened. You would have chosen the best out of the 3. But as far as you said that you were, because it's like, if you look at in your statement, you were fearing leakages. You wanted to rush on things and make it happen as early as possible. But during the course also, if you look at those who came here to give in their testimony, by going through their testimonies, you will see a lot of leakages also on their actions. So that is why I'm leading, whether there was preparedness for those people to take up those responsibilities.
The leakage I was talking about is the leakage before the order.
Exactly.
Not after the order.
Yeah, exactly.
Because after the order, the public ought to know, which is why I actually held a press conference. Now, the thing is this, if we wanted to just deal with one receiver, and if we had reached out to more than one at that time, it would have meant more than one receiver knowing about it. And the whole idea, again, as I said, was to have utmost discretion. We will come back to the issue of Augustus Prom being terminated, because that is not true. That is not the case. Augustus Prom was never terminated. But we'll come to that when I think we reach that issue.
Thank you, Chair. And thank you, Honorable, for having you. I want to start with the preparatory meeting you have with the cabinet, if I may be right. Could you recall, to be specific, those that, not in fact with the cabinet rather, but with your team of officials, I think the Department of Litigations, could you recall who were present in that specific meeting, either as individual or representing an institution?
Thank you, Honorable, for your question. I am a little bit old school, and what that means is I believe strongly in a civil service that is protected and that is insulated from political decisions. And that is why, if you notice throughout my testimony, I only kept making references to my senior management staff, members of the division of the civil litigation department. And that's simply because I do not want anybody to ascribe any responsibility to any of them. Because civil servants are supposed to continue and serve administrations, no matter which side of the political divide they are from. And that is why in typical democracies, political responsibilities are taken by the ministers, the head of the institutions, and you don't even hear the names of civil servants. And I think that used to be the case in the past. And personally, I would prefer to continue that fine tradition of protecting civil servants from political decisions. Because in processes like this, I don't see this hearing before this committee as an end in itself. I see it as a means to an end. And the end is to make sure that in these processes we also take the opportunity to rebuild and strengthen our governance structures. And I think a cardinal principle of that rebuilding process must be focused on the civil service, including protecting them from political decisions.
Yeah, that's a very fair response, Honorable. However, as you alluded at the start of the hearing that this very session is more of a matter of fact-finding. And also, just for us to be reminded that, which I know you are privileged to, Parliament cannot speculate. To expedite our duties, it will be indeed very, very important to actually share with us what would be the fact. Because you alone cannot solve all of these issues. And it wouldn't be fair to take that individual responsibility by saying, with the civil service, you cannot point fingers at individuals. There have been a lot of witnesses that have been before that seat. And this very question I have been asking you from the start of this committee's probing to date. This has been an answer that I have been looking for and I cannot get. And I was with the hope that if you appear before us, you should be in a position to provide us with detailed answers of some of the questions that seems to be unclear to us as a committee to help us in our line of reporting. Otherwise, we will sit here, do a work after 3 months, go before the plenary, we will be questioned. And as such, we cannot get you to provide us with those answers. So the best chance we got is for you to provide us with these answers. And if I can repeat, during this period of meeting, who were present in this meeting? And in addition, will it be right to say the then Registrar General was part of this meeting or wasn't part of this meeting?
Thank you, Honorable. I agree with your statement, except that I have answered all the questions. I will continue to answer all the questions that have been asked. But if I am being asked to identify civil servants who were in meetings with me, as I said, it makes it difficult because they should be protected.
Can I interject? Mr. Tambedou, can you kindly provide this committee with a detailed list of individuals who attended the first meeting you have with stakeholders, including the staffs of MOJ, to this committee? Chair, that is just an application to make things easy for him. Because he said he's an old school, he cannot recall all of these things, and aside that, he cannot be naming civil servants in such matters. And for us,
So-
the information is very, very relevant to our work because that should be the starting point.
So if I hear you well, Honorable, the request would be not personalities, perhaps office holders who are part of that meeting, if that is right.
If possible, names and institutions that they represent in this specific meeting.
Mr. Chair, with your permission, I believe perhaps having just heard his request again, I believe Honorable Jammeh may be mistaken about the meetings, because in the initial meeting before the order, there were no third parties. It was exclusively members of the Ministry of Justice and the receiver, Augustus Prom, in that meeting.
And I think Augustus Prom could be a third party in this situation, know him fully that he is not a staff of MOJ.
Yeah.
However, my interest is the staffs that were in that meeting and are from the Ministry of Justice, because certainly I know it will be the Office of the Solicitor General, Department of Litigation, and so forth. We want you to provide us with a comprehensive list of those attendees.
I am not sure I can recall even comprehensively, but we weren't many. It was a small group of staff, senior staff.
Honorable, are you telling me that during this meeting you haven't taken any minutes?
Honorable, now what to do is,
Let me just get an answer to this, then you
I
can.
want you to allow him to respond to the question that you first asked, and then you can come back again.
No, you know, I'm getting responses, and I think I should lead the kind of answer
No, maybe you
that I want
I-
in terms of what is also emerging from his end.
Okay, now let's do it this way. I just want us to be fair to the witness as well. Yes, you are responsible for your questions. You can ask anyhow. However, I wanted, if you ask, you allow him to respond. You understand? And then you can come back with your question again. Otherwise, maybe you will be cutting him short, and then he wouldn't be able to respond to the question that.
No, Chair, I think I am interjecting based on his permission. Until otherwise, if he should say he is not giving me that permission, he will prefer to continue making a statement. With all due respect, please.
I believe, Honorable, that this was a small group in the ministry. Apart from Augustus Prom, as I said, he was the only third party. The others were civil servants, and they're not ultimately responsible for any decision at the ministry. That responsibility lies on the shoulders of the political leadership. And that's why I said I am old school. I like to protect civil servants from public scrutiny such as this, because we're trying to rebuild our governance architecture again, and it's important that we revert to the old tested and tried ways that have worked and that have made us that has made our civil service the pride of the sub-region in the past. And I think we should all go back to those practices and insulate them from public scrutiny.
Honorable Tambedou, in your submission, you said there is a need for civil service reform,
Yeah.
meaning we should graduate from the old adage to a new system. So if we are protecting civil servants, do you think we can graduate from that old adage to a system that is progressive?
When you say old adage, it's relative. Where I want us to go is before the recent past. So basically, in the old civil service before the military takeover in 1994, we had one of the best civil service in the sub-region. Well trained, they went through apprenticeship, they were protected in the mold of the Westminster system of governance, if you like. And that worked well, and that's why after the 1994 military takeover, a lot of Gambian civil servants found their way in international organizations, helping to rebuild countries like East Timor. There was a decline after the coup, or up to when the change occurred, and that's why the government instituted a civil service reform to revert back to the pre-1994 days when our civil service was well trained, well protected, and neutral, politically neutral.
Mr. Tambedou, I think you joined the civil service in 1992, right?
1997, yes.
1997.
Yeah.
That was after the 1994 coup.
That's right.
So meaning you also form part of that system we claim not to really have a governance system that was appreciated either by the elites or by citizens. And just wait, let me come, sir. And when there was change of government, one of the reasons to bring reforms like the TJ, you name it, was actually to sanitize. And equally, I want to believe the process we are undertaking is also meant to enhance progress in our governance system. So I still want to challenge you to share the names of these offices or individuals who were present in this meeting. You know, possibly your intent might be very good in terms of, protecting people, which I appreciate. But by the look of things, for me, my feelings are people currently in the civil service who also serve as witnesses were here, and the concept we had was they form part of those that attended that meeting. And in order to clarify that, you could be very key in helping us to get clarity in terms of who was there and who wasn't there. And I please appeal with you to provide us with this.
No, I understand, Honorable. Again, just to clarify, my position is not to protect individuals. It's one of principle. As I said, the civil service or civil servants must be insulated from politics. It doesn't mean you can't call civil servants to appear and testify, but I certainly would hesitate to call names of people who are civil servants in a meeting where decision was ultimately taken and I was responsible as the Attorney General for that decision ultimately, even if I base my decision on advice from the civil service. It's a position of principle. I can recall the title holders of those who were present, but I would hesitate, with your indulgence, I would hesitate to provide specific names. But there were, I can call title holders.
To be honest with you,
yes,
we will appreciate the names and their office that they occupy then. I will definitely appreciate that for so many reasons, with all due respect, Honorable. Or otherwise, if my application is granted, because we are not moving, if my application is granted, I will leave the discretion with the chair to allow you provide us with this list tomorrow. That will be in camera. So you must choose what suits. Otherwise, I think I will stick at where I really stand at. And it's hot. Everyone want to go home. It's you who is keeping us here, Honorable.
So I just want to chip in here. Honorable, can I help, please? Now, Mr. Tambedou, what we will do, that's the request from the member. And I think as a committee, we are working together. Of course, members can have interest in so many things within what we are doing. But now, if you're able to recall the title, the position holder, the title of the offices, yes, you can provide that. And I think that will suffice. In fact, if you know the title holder, we will be able to recall the name who is responsible. I mean, from our own side, we will be able to know the honorable. So I think that will suffice too.
Absolutely.
Yes.
Chair.
I can give the title holders now. I don't have a problem with that. I was there. The Solicitor General was there. The Director of Civil Litigation was there. There was another Principal State Counsel or Senior State Counsel. I can't remember now what his title was. And of course, this part is not very clear to me. I'm not sure whether the Registrar General was also there, but I believe he was there because he would have been playing a very important role in this process. So I think the Registrar General was there, but don't hold me to it. I may be mistaken, but based on my recollection, I think he was there. So he was the Solicitor General, the Director of Civil Litigation, a principal or senior state counsel, and perhaps the Registrar General, and then Augustus Pom as well. These were the participants.
On this specific meeting, Honorable, do you have minutes of the meeting, or do you have an idea if minutes were taken?
No, no minutes were taken at this meeting.
Is that not a serious flaw?
At that time, it was not, because it was a quick meeting about what the application was going to be about, and that we should be prepared in the event an order is given, what we should do as next steps.
But presiding over state matters, knowing they are not private matters, will it not be important to find records of what was discussed during this period?
Honorable Jammeh, there were so many internal meetings at the ministry at this time with me and other senior leadership that it would have been impossible to take minutes of each of those meetings at that time. We didn't even have the capacity to do that. But there were a lot of meetings.
What makes it impossible, considering the fact that you have the human resource at the MOJ, and by the look of things and looking at the areas that they have intervened in terms of the sales of the cattle, the sales of the tractors, and every other thing, there was no point that, not even with you, nor with any of the witnesses that were there before you, claim to say they don't have the capacity.
We didn't have the capacity. Not only did we have the capacity, but we were having so many meetings on a daily basis that it was impossible to take minutes of all those meetings. Honorable, let me just remind you, don't forget that we were not only dealing with the freezing order, etc. There were many other activities that the ministry was also dealing with, and we were having meetings on those other activities as well. Imagine if we were taking minutes of all those meetings on a daily basis.
Honorable, let me also remind you that this is why not any other person were employed to occupy that office. This is why someone of your nature, as a perfect technocrat, was appointed to serve as the AG. And I believe the reason why the principal acted in that manner was out of trust.
And it's exactly because of those considerations from someone in my position that I am telling you now that it was virtually impossible to take minutes of all of those meetings.
Let's proceed. Let's proceed. The committee will take that up. Because for me, to be honest with you, I wouldn't really agree with anyone who will preside over government matters without taking records, because to promote transparency and accountability should start with data, information, etc. If those lacks, then.
Which is why I said right from the start that if you're looking for flaws, you will find them, because there's always room for improvement. There's always things that could be done better. But you were not there. We were at that time in the early days. We knew what the human resources challenges were at the ministry. We knew the amount of meetings we held, not just on these assets and the Jammeh Commission, but on the other aspects of the transitional justice process. In addition to the other day-to-day activities of the ministry, we were overwhelmed, to put it in short. We were extremely overwhelmed.
And for the purpose of records, Honorable, I want to say this. We are not really looking for flaws. Instead, we are looking for facts. And in order to get our facts right, we must probe questions that might be inconvenient.
They're not inconvenient to me at all.
Okay, let's look at the Anti-Money Laundering Act you talked about, which form part of the court order. Honorable Ba-Tambedou, reflecting on the evidence that are before us, I haven't seen in any record where the Anti-Money Laundering Act was mentioned as a base to establish a commission of inquiry on former presidents' properties or assets and related matters. What I saw I think I would in fact say it might be a motion, because I haven't seen any heading to the specific document, but I understand the document was signed by the head of state. And by the look of the preamble of the report, it explicitly talks about the inter alia. And by the look of the report, it seems is the inter alia that actually forms part of the basis to file an application before the court. And why the shift now from the inter alia to anti-money laundering?
Just to add on to that, I believe, Honorable, you're referring to MOJ2. The legal
MOJ2,
notice,
exactly.
The legal notice.
Yes, the legal notice, MOJ2.
First, there is no shift in terms of the legal notice and the Anti-Money Laundering Act. They are two completely different but linked processes. The Anti-Money Laundering Act was only relied upon to secure the freezing of the assets, not to establish the commission. The freezing of the assets was obtained so that the competent authority can conduct its investigations. The establishment of the commission formed part of that investigation. So there are two separate processes, even though they are ultimately linked. So Anti-Money Laundering Act was used to freeze the assets because the competent authority was conducting investigations. That investigation included the setting up of the Jammeh Commission. So I'm not sure if I have clarified.
My question still is, why is it that in all the reports from volume 1 to volume 9, the Anti-Money Laundering Act 2012 is not referenced?
Yes, because they are separate processes. The Anti-Money Laundering Act was used to secure the freezing order from the High Court. And that had nothing to do with the Jammeh Commission. So the Jammeh Commission's work was an investigative work pursuant to its establishment by the president. So you wouldn't see reference necessarily of the Anti-Money Laundering Act in the Jammeh Commission report because they are two separate processes.
Honorable, you said they are kind of linked.
Yes.
Now, let's take it in a separate angle. Let's look at the process of the sales. Was at any point the Anti-Money Laundering Act 2012 was applied, considering the fact that some of the buyers could hide behind anything to come wash their money? Was that applicable at any point?
I mean, I don't have problems answering that question, but I believe you're approaching this in a thematic way. I'm sure we'll ultimately get to that point. Or do you want me to respond to that, Mr. Chair, now? Because I can do that as well.
Chair, can I say this before you make a ruling?
Okay.
My question emerged from a response he gave to the lead counsel. So for me, the issue of a theme shouldn't be an issue. I am trying to make a follow-up question on a response he gave. So I believe he should be in a position to actually enlighten us as a committee.
Okay. I think you. So Honorable, yes, I had a question. So because you were being specific on the issue of sales, and I think we are dealing. No, I understand. Yeah, I understand. Because when you ask.
Mike.
Like I did with the order.
Yeah, now, because if we.
And even the sales was mentioned by him here. He talked about tractor sale. He talks about vehicle sale. He talked about even the rams, even the hyenas.
No, you are right. You can ask questions. You can ask your question. Any type of question you can ask. However, because we said we wanted to approach the issue on a thematic base, that is our decision as well with the council. So if, in our opinion, that you have asked a question that has touched another thematic area, it's still not bad. That question can still come back even tomorrow when he appears again. You can refer him back to that question again and link it to what is happening today, and then you can get your response and we move on.
Chair, can I appeal?
No, I understand where you're coming
Chair, as I said, repeatedly,
yes.
the issue of the anti-corruption have been alluded by the witness before us. And it will be important for we to correlate in order to get the facts right. Having him to wait until tomorrow is really a possibility, but what I am saying, this is not something that is been said, that is going to be said tomorrow. This is already said today repeatedly.
Okay.
If the council can guide us.
That's okay. Now, I actually will allow you to ask that question again, and let's hear it properly, because it seems I missed something in that question. That's why I said you're being very specific about sales. Ask it again, and then we will be able to determine exactly what.
Chair, I'm glad that you said it seems you missed something.
When I said you're being specific about sales, you said no, because this question was.
No, I just took reference on sales around the. Yes, you can interject.
Honorable, I didn't want to interject, but let me just do briefly. I think you are on spot, but what we do is not to preempt what we might ask. Because personally, I have great interest in the sales. Not to preempt it. I would appeal, you bring that down, maybe you can rephrase the question. And then the issue of anti-money laundering, whether it applies in the sales, you can follow it substantively when we reach there. Because as it stands, the moment he answers, maybe 5, 6, 7, or 8 questions that we have in that area would just go off.
No, for me, I was thinking, Honorable Member, with all due respect, you people were going to reserve your questions around the anti-littering thing and not to really go in deep. This is why I'm just trying to touch on the basis. And however, I will let it rest. No, I will let it rest.
Allow me. Can I get it? And you get it right, because I don't have any questions to get. That's why I'm appealing. We wait for that tomorrow. But still your question is valid. Rephrase it and take the anti-money laundering out of it, and you can push it still.
No, don't worry. I will wait until tomorrow. If the lead council have an extensive discussion around it.
Then we can comment.
Okay. Okay. Maybe this one I will just make few requests. No, it's all right, Chair. It's part of it. I'm here to be guided. So I'm really comfortable with that. Honorable, I think around the freezing order, a lot have been discussed on it. And I'm not sure it would be a matter of a thematic area that we cannot discuss, because this is what I really want to look at this time. With the freezing orders, I understand that we get some materials that were submitted, but you being the then Minister of Justice, I just want to make this application. If you can provide us with all extensions for the phrasing in case if any apply. Also, I want to apply if you can provide us with refusals to rulings in case it applies in any of the orders. Also, vacation court grant with some additional informations. I understand there are also some rulings made during a vacation period. If you can also provide us with that ruling. I'm not going against the idea that we might have it, but these are materials that I think you should be the right person to provide us with. More especially with your statement that with the look of things, you don't really want to put any of your people into a situation that would be unbearable. So this is why I want to ask these things through an application with the chair.
If I may.
Mr. Attendees, yes, can you come in?
Yes, if I may. Honorable, in principle, I don't have a problem looking for the documents that you've requested. Unfortunately, I have little time. I came all the way to spend this week here. I cannot now start writing to the High Court looking for copies of rulings or doing that research. When the High Court is here, the Ministry of Justice is here, they are the offices of record of what you're asking me to provide you. And I was hoping that your investigators would have already secured all of these documents that you have in mind for me. But in particular about the vacation rulings, I suspect I know what you're referring to, but I don't want to make any assumptions in case I am mistaken. But when you say there were rulings during the vacation rulings, in respect of what? Of the freezing order?
I think it should not be in respect to a freezing order. I think it should be in respect to an extension of time or the appointment of a receiver. Was there any ruling? Let me just be specific. Was there any ruling made by Justice Jaite?
It was with respect of unfreezing land in the TDA area.
Unfreezing land
Yes.
on.
So that's why I said whether it was.
This is the very ruling I want. You know I have a tourism background. And I want that TDA to be protected. So I want to know how much is it protected.
I think the Ministry of Justice is the office of record. And what you're asking me to do is to write and follow up with the ministry and the High Court. And I don't have a mobile office. I am here.
No, but Mr. Tambedou, you know, during your submission, you were very explicit. You said, at the time when everything was starting, the executive were relying on 3 people who has a legal background. Aside from that, I am with the strong belief you one time occupied that office. You played a role in those motions or in those orders. So as such, it will be appropriate to receive the said documents from you than from the current MOJ minister even. And even though you are not in that office, I believe with your influence, with your status, you should be able to communicate this request to the relevant offices and retrieve these documents and submit by Friday if need be. I can in fact give you a lengthy time.
No, I don't have a problem making the request. It's just that those applications and the decisions were not directed to me as an individual in my personal capacity. They were addressed to the Office of Attorney General, which is a continuum, right? It's the office as an institution that those orders and applications were made. So it's easy for that office to provide those documents than me as an individual. I don't have them.
Honorable.
Yes. But I will do, let me do my best. Let me reach out to the ministry and to the High Court and see what they can provide for me.
And also let me say this. You are not on that seat because of you as an individual. You are occupying that seat here today because you one time served the capacity of Attorney General. So as such, we will be very interested to follow track of some of the activities you have participated in. Because there are a lot of speculations, sir. And it's equally our responsibility to put the facts right than alleging individuals on no grounds. And the best way to get the facts would be getting some of this information from you. Then we can also contrast with what was submitted from the current MOJ minister or any other office that was responsible. I think I will take a break here until tomorrow. But, Chair, if I may remind you, I don't know if my application is granted in terms of honorable to produce certain documents. Yes. But until it's granted by the boss. Thank you.
In his own capacity as, no, I just wanted to, I wanted to say, yes, Mr. Tambedou will try to get the document from Minister of Justice and the High Court in his capacity as Mr. Tambedou. But of course, that document, like he said, should be with the Minister of Justice. But do your best to get it for us. Otherwise, we will still also want to get it from other sources. But definitely, we'd want to get it from you. And that will also show us the link that you have with Minister of Justice to get that document for this committee, okay? Yeah, thank you so very much. Thank you. Council. Yeah. Okay, okay. I'm being told there was another request for the FIU report. That can also form part of the request you are going to make. I don't know. Okay. You can request. I mean, just make the request. I'm sure you will be able to get it, huh? So that the submission can come from you as an individual. That's important.
I'll do my best.
Yeah. Council, at this point, do you have any further clarification before?
Well, I have one, but I can see the discomfort around the room. So perhaps let me reserve it till tomorrow, once everything is in order.
All right. Okay. Thank you, Mr. Tambedou. So we will close for today. We'll adjourn for today till tomorrow. Mind you, we will be with you for the rest of the week, and you'll be with us. Sure. So tomorrow we will resume. We'll start at 12 o'clock. 12 midday. Because we'll have in the morning we'll have some logistical arrangements for this committee as well. So we need to work on that first. So we will adjourn for today till tomorrow, 12 o'clock. Meeting adjourned. Thank you.
Thank you, Chair.